Hey corporate law fans, Professor Oranburg here with a review video for you talking about my top 5 topics in corporations. This should help you prepare for the bar exam or your final exams, or maybe just a refresher on the top 5 things I think are important about corporation law for you to know. So let's go ahead and get started. Today we're going to cover 5 significant corporate law topics for you with a brief review and recap. So without further ado, let's go to number 5. Our number 5 corporate law topic is agency and authority, the relationship between principals and agents, how principals can cause agents to act on their behalf, and when those actions are and are not authorized constitutes agency and authority law. Starting with the restatement third of agency, we know that only principals can authorize agents to act on their behalf. And how does a principal authorize an agent to act? Well, authority can come from an actual grant of authority. This is when a principal says or writes to an agent that that agent has the ability to do a certain task. When it is said clearly or written down, we call this express actual authority. In addition, by virtue of the relationship between the principal and the agent over time, some actual authority is implied. But the key thing to know about actual authority is it is all about the relationship between the principal and the agent. The agent has to believe that he is in fact authorized by the principal. Next, we look at apparent authority, and this has to do with whether a third party would reasonably believe that the agent was authorized to take a certain action. So now we look at the perspective of what the principal has manifested to a third party. We still need a principal to make a manifestation, but unlike actual authority, where the manifestation by the principal is made to the agent, in apparent authority, the manifestation by the principal is made to a third party. In addition, the second restatement of agency, and again, we're on the third restatement now, so this is in some ways old law in some jurisdictions, but the second restatement of agency had a concept called inherent authority, which meant that a person with a certain title or position was cloaked with authority by virtue of having that position. But really, this is actually quite similar to apparent authority, because when the principal makes a manifestation like, hey, this is my CEO, third parties would reasonably believe that that CEO has certain powers. And so the concept of inherent authority has been wrapped into that of apparent authority in the third restatement. One last concept before we move on. Once a action has been taken, it can later in the future be made authorized by a ratification. A ratification relates back to a prior action and authorizes it retroactively. There's a cost to having an agent because the intentions and desires of principals and agents aren't always aligned. For example, the principal who hires someone wants them to work as much as possible, whereas the person who's working probably just wants a paycheck. So let me tell you a little story that might help you understand agency costs. It's by Dr. Seuss, and you don't often read Dr. Seuss in law school, but I'm telling you, it's very relevant. Oh, the jobs people work at. Out west near Watch Watch, there's a Watch Watcher bee watcher. His job is to watch, is to keep both his eyes on the lazy town bee. A bee that is watched will work harder, you see? Well, he watched and he watched, but in spite of his watch, the bee didn't work any harder, not much. So then somebody said our old bee watching man just isn't bee watching as hard as he can. He ought to be watched by another watch watcher. The thing that we need is a bee watcher watcher. Well, the bee watcher watcher watched the bee watcher. He didn't watch well, so another watch watcher had to come in as a watch watcher. And today all the hotchers who live in Hotch Watch are watching on watch watcher watching watching the watcher who's watching the bee. You're not a watch watcher. You're lucky. You see? And I hope that you see that there is a cost to agency. We have to monitor the agent in order to ensure that they're fulfilling the role of the principal. And see, Dr. Seuss does have something to say about corporate law. In fact, in order to have an agent, we need to monitor and bond with that agent and expend certain costs. How does this relate to corporate law in particular? We sometimes have a rogue manager, a rogue CEO who is doing something that benefits himself or herself and not the corporation, and the corporation may not want to be bound by this transaction and will claim that that transaction was not authorized. Or a third party might enter into a transaction with a corporation and later claim that that transaction was not authorized and try to rescind or revoke that transaction. So we have to actually look at the sources of authority to see if we can determine a transaction was authorized or not when these issues come up. Authority can come from many different sources, but express authority in corporate law often comes from the state business statute, the corporation's certificate of incorporations, the corporation's bylaws, or from a board action. The board is the ultimate situs of power in a corporation, and so at a meeting, they can delegate authority to take an action to an officer or another corporate employee. However, the board resolutions must be done at a meeting unless it's one of the exceptions to the meeting rule, and meetings must have notice and quorum to be valid. Once a lawyer has determined that a transaction is authorized, that lawyer may write what's called a legal opinion, telling the other parties in that transaction that the corporation has in fact authorized a transaction. Take a minute to look at this handy-dandy slide, which goes over who can act whether we have an ordinary, extraordinary, or fundamental transaction. We have three major types of characters: shareholders, who are the owners, but of course in corporations there is a separation of ownership and control; the board of directors, who have the ultimate authority for the corporation; and executive officers, who typically run the day-to-day actions. And as you might imagine, the executive officers are the ones who typically handle ordinary transactions. The board is required to approve or to make extraordinary transactions and actions, and shareholders are required to approve fundamental transactions, but in general do not have the ability to run the company on a day-to-day basis. Corporate law topic number 4 for today is entity selection and formation. How do you choose from that whole alphabet soup of different acronyms for entity types like general partnership, limited liability company? Well, the answer to that will be found in this next section. Entity selection and formation has to deal with the alphabet soup, the myriad of organizational forms and choices you might have when determining what type of corporation to create. They are general partnerships, limited liability partnerships, limited partnerships, C corporations, S corporations, benefit corporations, limited liability companies, low profit limited liability companies, and more. So how do you decide from this myriad alphabet soup what type of entity is best for your client? Here are some guidelines as to the common business uses and a few suggestions here. One of the most common business entities that exists is simply a sole proprietorship. Anyone who simply begins working on their own has in fact formed a sole proprietorship. This is good if you are in a low risk or short-term business, but it is terrible if you have any risk that is of consequence, because sole proprietors have unlimited liability for the debts and the torts of the business. One way to resolve this, very simple, very cheap: form a single member limited liability company to limit the liability of the sole proprietor. Again, a sole proprietor would have unlimited liability, so it is most useful if we have a very short-term business that isn't worth the very minor expense of creating an LLC. Next, we have general partnerships. These are also useful in a small, short-term, low-risk context, and the thing to know about them is they can be formed by accident. Anytime two people carry on for profit a business, they have in fact created a partnership, and now they are jointly and severably liable for the business and to each other. Whoa, even more liability. So what do we want to do about this liability? We want to limit it. How do we limit liability? We choose an entity with limited liability. The most common choice here would probably be a multi-member, member-managed limited liability company. Next, we have the classic limited partnership, which is a form used almost exclusively for investment funds. We can upgrade or improve on this limited partnership with a multi-member manager-managed LLC, where the general partner becomes the manager, the limited partner is the member, and this obviates the need for what is called a blocker corporation, where the general partner in a limited partnership is actually a corporation, because otherwise the general partner is personally liable for the debts of the partnership. Next, we have C corporations, which are our general choice for high-growth business entities who need outside investors. The downside is they have double taxation. So if you're trying to avoid taxation, well, perhaps you can use a LLC, which is a flow-through entity. It doesn't have tax on its own, or you can make an S corporation election. This can be useful if you have a closely held business, but there are a lot of limitations on S corporations, limit on the number and nature of shareholders, and so you may not qualify. If you have a business which is better off as a flow-through and does not necessarily need outside investors to be a high-growth enterprise, consider using an LLC instead of an S corp where you can't meet the S corp election. And once again, a handy-dandy chart for you to compare how formation, liability, control rights, financial rights, continuity, liquidity, and mergers are different across general partnerships, limited partnerships, C corporations, and limited liability companies. One issue that often comes up in incorporation is defective incorporation. Well, I shouldn't say it often comes up. It often comes up on the bar exam. I'm not sure how often it comes up in reality, but the fact pattern presented is going to be something like a person said that they had a corporation and they didn't, or a person tried to form a corporation and they failed to do so. So, are they going to enjoy limited liability even though they never actually formed a corporation? And the answer is, it depends. It depends on whether or not justice requires that we give them limited liability. The first doctrine that would give them limited liability, even though they didn't follow the formal requirements, is called corporation by estoppel. A corporation by estoppel occurs where a third party reasonably believes that a corporation exists. And since they thought they were dealing with a corporation when they got involved in the transaction, we're not going to give them the benefit of unlimited liability after the fact. A de facto corporation is another equitable doctrine that can occur where the incorporators made a good faith effort to incorporate and were unaware of the defect in the incorporation and then conduct some acts on the corporation's behalf. Once again, we have to find that it is equitable or that justice requires this result in order to grant a de facto corporation, which would then give the promoter limited liability even though they failed to file their forms correctly. Our third corporate law topic is securities, which involve how people raise money for corporations by issuing stock and bonds. On your screen is a very simplified picture of the securities of a corporation, and what I want to point out is there is a correlation of risk and reward. In other words, in order to get a higher reward or a higher return, you need to take a greater risk. The most risky asset that you can purchase is going to be your common stock asset, which is going to be repaid last, but you get all the residual. In the middle is preferred stock, and what is paid first in a corporation is long-term debt, the least risky, but also comes with the least amount of reward. How does that play out in a variety of scenarios? Well, we have something called a liquidation payout waterfall, where we determine how well the various security holders are going to do in the instance of a sale of a company. And in this wonderful picture, we have a gushing stream. The debt holders are totally repaid, but as soon as they receive all they're entitled to, the rest of the money spills over to the next category. And the preferred stockholders are also entirely repaid. And then the massive glut of funds that still remain go to the common shareholders, who are going to be delighted because they are now exceedingly wealthy. On the other hand, if there isn't very much money at a liquidation event, the debt holders still get paid first, and whatever is left over, if any, will get next paid to the preferred shareholders. And at the end of this pathetic trickle are the common shareholders, who end up with very little or nothing in this worst case scenario. So you can see that although the common shareholders can do very well, they also take on the most risk because they are paid last. Stock is the most common type of corporate security that you'll deal with in corporations class, and in fact, stockholders have special rights. What is stock? Stock is authorized by the certificate of incorporation, and it represents a share or a percentage interest in a company. It's actually ownership of a corporation. While it is authorized by the certificate, it can only be issued by the board of directors, and again, they have to follow the meeting rule. Once it's issued, it becomes outstanding, meaning it's held by somebody else. It can be repurchased and therefore becomes a treasury share. Can stock be sold? Well, technically, yes, but there can be a myriad of transfer restrictions, whether in the bylaws and shareholders agreements or in securities regulations themselves. Stock may not be so easy to transfer in practice. And speaking of those securities regulations, here is my best effort to combine all of SecReg into one slide. So here we go. Securities regulations covers all securities, which are defined as stock, bonds, and specific common instruments that are also named, and a category called investment contracts, which are defined by the Howey test. And they are a transaction in which a person invests his money in a common enterprise, is led to expect profits solely from the efforts of others. See Howey. Pursuant to the Securities Act of 1933, securities cannot be sold to the public unless they are registered or exempt. And pursuant to the Securities Exchange Act of 1934, securities sold on registered national securities exchanges are subject to special anti-fraud provisions, see 10b and Rule 10b-5, and periodic reporting requirements, see Section 13, and this is our friends, the 10K, the 10Q, the 8K, etc. Our number 2 corporate law topic, we're getting to the top here, is stockholders. Stockholders have 3 fundamental rights: vote, sue, and sell. Let's see how that plays into our corporate law picture. Shareholders have 3 fundamental rights. They can vote for new management, they can sell their shares of stock if they're unhappy with their performance, or they can sue management. Let's talk briefly about how stockholders can sue, because there are 2 main forms: direct actions and derivative actions. The first thing to note is that we have to determine whether an action is properly direct or derivative, and has to do with to whom is the harm and who would receive any recovery in the event of a successful lawsuit. So direct litigation typically involves the financial rights of shareholders as shareholders, like dividends that they are entitled to be receiving. Voting rights are also direct rights of shareholders, where it is their right to vote that may be impinged upon by a change in the voting process. Similarly, are governance rights, like the right to have meetings at certain times, or minority shareholder rights. And shareholders also have rights to information. If any of these rights are stubbed on, then the shareholders can have a direct action against the directors. And in fact, they can get together and have a collective direct action called a class action to reinforce those rights. On the other side of the ledger are harms to the corporation, where the shareholders are only harmed derivatively because their value and their investment has been diminished. This includes usurpation of a corporate opportunity, when a director takes for himself or herself, or a CEO or officer takes for himself or herself, an opportunity that was properly for the corporation. A waste of corporate assets by the directors. A director engaging in a conflict of interest transaction, where the corporation gets the short end of the stick, or overall poor performance of the corporation due to the director's breach of their duties. So once again, the first thing to note is that direct and derivative actions come from impingement upon different rights, and we need to determine which are which. If we determine that we have a derivative litigation, in other words, if the shareholders are trying to enforce the corporation's rights to have the corporation's opportunities given to it and have it managed properly, we are in the realm of derivative litigation. And derivative litigation's a little weird, because a derivative litigation means that the shareholders are causing the company to do something. And as you may recall from the beginning of this lecture, the shareholders are owners, but they don't control the company. They don't cause it to engage in day-to-day actions. That's the directors and the officers' job. So derivative litigation needs some kind of exception, because the directors are sure as heck not going to sue themselves. So we have to have this procedural mechanism where the shareholders can actually cause the corporation to act, even though that's not typically how corporations operate. And they do so by alleging, well, first, they could allege that they made efforts to get the directors to act and the directors failed to act, or they could argue that there was no point in even asking them. Much more common is that the shareholders will claim that demand on the board to sue the board would have been futile. And the plaintiffs, the shareholders, can overcome the heavy burden of showing that they have the right to take power away from the directors and cause the corporation to sue the directors by showing that the board is self-interested and therefore is lacking in independent judgment, or they're not really challenging a business judgment, they're challenging something else, as we'll see when we talk about the business judgment rule. Shareholders can also be liable. At the organizational choices portion of this review, I discussed how limited liability really advantaged shareholders so they weren't personally liable for the debts and torts of a business, but that limited liability itself has its limits. The corporate veil, so to speak, can be pierced. And yes, we are talking about piercing the corporate veil. And when will a corporate veil be pierced? Well, we have a set of factors. There's no one particular test, but when these factors are present, courts are more likely to pierce. When a corporation is closely held, when insiders deceive creditors, when insiders failed to observe corporate formalities, when insiders commingled business and personal assets, when insiders inadequately capitalized the business or failed to have the proper legally required insurance, where a defendant actively participated in running the business, or when the defendant is otherwise a bad actor who has abused the corporate form and so is effectively equitably stopped from hiding behind its limited liability shield and is pierced. And last but not least, our number one corporate law topic is fiduciary duties, which has to do with the relationship between directors and officers and the corporation that they serve, and the rights of shareholders to sue for breaches thereunder. At the heart of corporate law are fiduciary duties, our number one topic. First and foremost is the duty of care and its partner, the business judgment rule. The duty of care requires directors to act with care when making business decisions, and if they fail to act carefully, they are liable. The business judgment rule, however, presumes that directors act carefully, so it is actually very hard for shareholders to show there has been a breach of the duty of care because they have to overcome a rather high barrier. The business judgment rule provides a rebuttable presumption that the directors acted carefully, and the shareholders in a lawsuit have to overcome this rather high hurdle. How high is the hurdle? That depends on what jurisdiction you're in. The lowest hurdle is the hurdle articulated by Schlensky versus Wrigley, a famous case in Delaware, which effectively held that directors' decisions will not be questioned so long as there is some rational basis for that decision. That's a really low standard, the rational basis test. Then came Van Gorkum in the 80s, another Delaware decision, which held that directors' decisions must be predicated by sufficient paper and process for that presumption to attach. And so now this is a bit of a higher standard, and the directors have to have a sufficiently long meeting and have gone over enough data and documents in order to get the benefit of the business judgment rule. And then in Model Business Corporation Act jurisdictions, including Pennsylvania and many others, the business judgment rule requires something more. It requires good faith and reasonable belief on the part of the director. And now we get into this concept of reasonable. That means that an objective director, not this director, but some artificially constructed model of what a reasonable director would have been in that position, would have acted in this way. And that is a higher standard in principle, although directors still enjoy a great deal of protection from the business judgment rule, even in MBCA-style jurisdictions. And notably, in Delaware, corporations can actually opt out of the Van Gorkum middle stage by electing what's called an exculpation provision in their certificate of incorporation, which allows directors almost unlimited deference and basically puts the corporation back into the state of affairs that would have existed under Schlensky before Van Gorkum. Next is a director conflict of interest transaction, which occurs when a director is on both sides of a transaction. This doesn't mean a deal is unfair. In fact, it happens all the time. It just means that that director loses BJR protection, doesn't get the benefit of the business judgment rule because we're now, not sure that he's making a business decision. Maybe he's doing something that benefits himself. When I say these are common, how common? Real common. Anytime a startup company takes on a large investment, the investor is likely to put a director on the board of the target company. When you make a big investment in a startup, you want to put an adult in the room to make sure that the kids are playing nice with the money you gave them. And so you put a director in the room to sort of watch over them and guide them and what have you, and that startup is likely to need more money in the future. Who are they going to go to? They're going to go back to that same investor. And now what's the problem? The problem is there's a director on both sides because there's a person who is a director of your startup And that person is also part of a managing partner in the investment fund, and you are now negotiating with them. The investment fund wants to pay as little as possible for the stock. The startup wants to get as much as possible for the stock. Do you see the problem here? It doesn't mean it's a bad deal, though. It just means that we need to have disinterested and independent directors or shareholders cleanse the transaction. They have to review the deal and determine that it's fair. Otherwise, a court's going to have to determine if it's entirely fair, and that's a little sketchier. And by the way, special litigation committees, which are formed to determine whether or not a shareholder's demand to sue directors can go forward, special litigation committees are held to a somewhat higher standard than directors are in general. And then we have the corporate opportunity doctrine, which is a huge part of the duty of loyalty. Directors are supposed to be loyal to their corporations, always looking out for their best interest. And so a director cannot take a business opportunity for himself or herself if, well, here we have what are called the corporate opportunity tests. If any of these are met, then the director needs to leave that deal alone, or at least give the corporation an opportunity to reject it. So a corporate fiduciary, such as a director, cannot take a business opportunity for himself if it is one the corporation can financially undertake, if it is within the corporation's line of business, if it is advantageous to the corporation, or if it is one in which the corporation has a reasonable expectancy. Unless he presents it to the directors, who decide, after having been fully informed, that it is not valuable to the corporation and they reject it, only then can the director take the opportunity for himself or herself. Well, that's it. That's my top 5 corporate law topics. And thank you for hanging out with me for a little bit as we reviewed this law. Once again, our stars of the show, our top 5 topics, coming in at number 5, agency and authority concepts, making sure that transactions are properly authorized. In number 4, entity selection and formation, getting the right vehicle for your client's business needs. In number 3, securities, raising funds and having that waterfall pay out when a transaction liquidates a company. Stockholders, who have rights to vote, sue, and sell, and have special rules when they cause the corporation to sue the directors for a breach of, number 1, fiduciary duties, those all-important duties that directors and officers owe to the corporation and that stockholders can litigate for in certain instances. Hey, corporate law fans, Professor Oranburg here again, signing off. Thank you for staying tuned and watching this video on 5 topics in corporate law that I think you should know. I'll see you next time.